How are you?
I am fine, I guess. Thank you.
Okay. I'm fine too, I guess. In my culture, it's customary to extend the courtesy to the other party
right.
as well.
You're very right. I could be excused under
Under the
the pressure of
circumstances.
the moment.
Indeed,
Sorry
you
for
are
that.
excused. You have a long list of academic qualifications, and I'm wondering where you find the time to study all these. You have a Bachelor of Arts degree from the University of Venda and
Correct.
a Bachelor of Laws from the University of Pretoria, two Master of Laws degrees, one in tax law from VETS, the other one in mercantile law with a focus on insolvency on insolvency law and liquidation law from the University of Pretoria. Then you did a postgrad diploma in forensic and investigative accounting,
Correct.
and you have a Master of Business Leadership from where did you
UNISA.
attain that from UNISA?
Yes.
And then you did an advanced short course in business rescue practice
Correct. Yes.
with UNISA again, and you are currently registered with UNISA for a Doctor of Laws in mercantile law,
That's correct.
and you are practicing as an attorney since 1 February 1995.
It's 1996.
19
1 May.
Well, I'm looking at. Oh, sorry, you were still doing your articles in 1995. All right. You started at the state attorney's office.
State attorney was just when I was about to be admitted.
Mm-hmm.
My articles were somewhere else. One firm in Johannesburg, and then I ceded to Pretoria.
Mm-hmm. So you didn't stay long with the state attorney. You became a professional assistant at Matlala Incorporated, and then changed law firms, and then had your own by 1998 in partnership with other parties.
That's correct, yes.
Right. And you are still practicing as an attorney now.
I am still practicing.
You have acted in the High Court, this particular one to which you are applying, not so.
Excuse me, I didn't get that.
You have acted as a judge in the High Court.
Yes, I have.
In the Gauteng division, in both seats of the Gauteng
Yeah, both
division.
the Johannesburg and Pretoria.
All right. You mentioned 98 weeks. Is that the extent of your acting experience as a judge?
That number wasn't entirely correct. I should apologize. It was actually 97.
97.
As at the time of making or submitting the application.
Mm-hmm. Have you acted since?
Yes. The total now is 105.
105. In that time, in which courts have you sat?
I've sat in most of the courts. The one that comes to mind where I haven't sat is the criminal court. I have only done criminal appeals and bail appeals.
All right.
Then I haven't also sat in the tax court, although I had the benefit towards the end of last year of a special motion involving tax law, that is the commissioner and other parties.
In how many criminal appeals have you sat?
Criminal appeals?
Yes.
May I refer, Madam Chief Justice?
Sure.
Someone might have think that. The criminal appeals is 44.
Oh, that's a significant number. Full bench and full court?
Yes, very few full court. I think full court appeals, I could say less than 5.
Have you written any judgments in those matters?
Yes, I have, mostly in the full bench ones. In the full court appeals, I had the benefit of writing what was initially a minority judgment, but at least upheld at the SCA level. But when I wrote the judgment initially, I had meant to just share my views with the other judges because at the prima facie level before we could decide, I had a different view. And then I said in the area of criminal law, I wasn't familiar with the principles. I better write and they see where I'm getting that conclusion. Maybe if they see the path that I traveled to reach the conclusion that I was at, they might maybe see things my way. But then, obviously, there were the 2 other judges wrote in concurrence what became the majority judgment.
Mm-hmm. And you say you were upheld in the appellate court.
Yes, I was.
Must have felt good.
Yes, but the only sad part is that it involved 5 accused, and only I think 3 or 2 took the matter on appeal to the SCA, and they were released ultimately. I followed up with the legal aid board too, but obviously I couldn't keep on following up as to what is happening with the others.
With the others?
Yeah, they assured me that there are processes, but I don't know what happened.
All right. One hopes that they would have been informed about this so that they enjoy the benefit as well. Okay. How many judgments in all have you written?
My total judgments, if I may refer again, Madam Chief Justice, it's 185.
185. Have any of them been reported?
Very few. 2 of them have been reported, save for that minority judgment at the full court level. But mine alone is only 2.
Okay. Your description of your practice does not seem to include any criminal work.
Yes, that's true.
You have not done criminal work.
I had only done it in the earlier years. Okay, when I did my articles, yes, it was there. And when I started practice, it was there. And initially, the legal aid board could involve practitioners directly, and then, but obviously, I can't blame the legal aid board. I think I switched focus to aspects that were not to do with criminal.
You listed a number of reserved judgments in your questionnaire, some dating back to March 3, 2. What has been the fate of those judgments?
They've been delivered, all of them.
All right. You list a few bodies in which you have been involved as part of your involvement in the wider community. You've been an instructor at led law schools since 2000.
That's correct.
And you say you've conducted seminars, webinars, and addressed conferences.
Yes, that's correct.
In which areas of the law?
Mainly in, I'll say, company law, and then insolvency and liquidation law. Then, but with the law schools as well, there's been mainly insolvency law.
All right. And you also state that you've written, well, you've had a few articles in non-peer reviewed journals, published journals and newsletters. Was that also on insolvency law?
Insolvency law, and I think, if I may refer, there were a few others in other aspects of law. But as I've emphasized, that was non-peer reviewed journals. Madam Chief Justice, if I can refer to page 25.
We've just been asked to stop the proceedings for a minute just to make sure that the recording equipment is back on. Can we continue? Oh, we were still talking about your published articles.
Yes, I was on page 25 with the, or 24 with the hand marked. When I was saying there is one on Social and Ethics Committee, which is company law, and then another one company law, and then insolvency.
Yes.
But those are, and then the conferences, those are not your, what I can call serious journal articles. It's commentary more or less.
All right. And you also train candidate attorneys and junior attorneys, and do you teach, or what do you do at law schools around the Gauteng province for the law society?
It's teaching.
It's teaching.
Yes, it's teaching.
All right.
It's okay, but maybe the correct reference, they say tutoring, but all school we can say teaching.
All right. Thank you, Mr. Manamela. I'll hand over to AJP Ledwaba to put questions to you if there's any.
Thank you, Chief Justice. Mr. Manamela, let me take this opportunity to also thank you for almost always availing yourself when I called you to come and assist, with acting when one of my judges would be booked off for health reasons.
Now, thank you for the opportunity, acting JP, sorry.
I see that you've been acting since 2013, or almost every year. Actually, every year you did act in the Gauteng High Court.
That's correct.
And the number of matters you've said in, they speak for themselves. You have also indicated that it's only the criminal court and the tax court that you have not said in. Let me know, have you applied to be appointed as a judge before?
No, this is my first time.
But why did you wait for so long? It's more than 10 years.
I think mainly I was afraid of this chair I'm sitting on now. But other than that, it was mainly to do with family. My children were still small. So there was that need for time to be there in their activities. That's why if one looks at the number of stints, they start increasing when they were often mature age and getting out of high school. But more or less, it was also some level of indecision to make the final commitment. But now I'm here, and I think I am ready to make a contribution.
And even earlier, the leadership of the court, the JP, did encourage you, and I also encourage you that you should avail yourself.
Yes, yes, you did throughout. Yes.
Okay.
Thank you for that.
Maybe since you indicated that you've never been in a criminal court, you said that in practice you did that work. During your acting stints, did you also have an opportunity to deal with petitions, criminal petitions,
Yes,
automatic reviews?
Yes, I think it's. I can't remember how regular they do come, but I think every stint there will be one or two petitions and the automatic reviews.
And how was your experience in being in the urgent court, being the busy one wherein you are expected to deliver judgment as soon as possible because of the urgencies of the matter? I see you've been in the urgent court for 6 weeks.
Yes, quite challenging because you don't have the benefit of time, as you mentioned. You have to decide on things when you're required to. But what is more helping is the resources around. I find that at the beginning I was able to confer, that is in the earlier years, with the senior colleagues. But obviously, as time went by, I obviously used less and less of them. I'm referring to things of, how do you, if I can give an example of you get into an agent court where the matter was not necessarily enrolled, but it comes through right there. It gets daunting because you haven't even gone through the papers, and then now you are supposed to deal with the issues. And then in earlier days of my stint, I felt pressure that I had to deal with the mess if there was no sort of interruption, because I'm saying to myself, the parties are looking for the same way of their matter being adjudicated upon like any other party. But then you get to realize that no, it is something where you can manage your own role as to when you're going to hear which matter, as long as that is convenient to the parties, including the legal representatives, and also that it doesn't obviously affect the nature of the harm that has been avoided or contemplated.
At your law firm, do you have partners, PAs?
Yes, but at the moment we are very thinly staffed. We are only 3 lawyers, but it goes with the level of work or the amount of work that we have. So I do have a partner and a PA who is a quasi-partner.
I'm trying to put you in a corner. Should this commission recommend that you be appointed, how soon can you start?
I think I've been spending more days acting JP at the court more than the practice. So to answer directly, I don't think they will miss me that much. My involvement has been less and less over the years, and some of it not by choice, but mainly because I was at the High Court most of the time. So I should be able to start as soon as I'm required.
Thank you, Chief Justice.
Premier.
Thanks, Chief Justice. I'm fully covered. Thank you.
Minister.
Thank you very much, CJ. Good afternoon, Mr. Manamela.
Good afternoon, Minister.
Question on your questions, question 3. You highlighted that you were previously found guilty by a professional body in terms of your submissions, that you made late submissions in 2004. What was the reason for the late submissions?
I guess I can just say I didn't do what was expected of me by the rules, which was regrettable. There were issues that led to that. At the beginning of the year, I had the unfortunate issue of separate. I was in a two-partner firm or two-director firm at the time. So beginning of that year, there was a separation. I even had to go to court to get a court order, which didn't really help. Thereafter, we pursued mediation that helped. So that affected the auditors and bookkeepers accessing material for purposes of drafting or complying, helping me comply with the rules. But obviously, I was supposed to manage all that and ensure that what was supposed to happen should happen on time, but it didn't. I learned my lesson, and I even went as far as augmenting my management skills, even academically, as the Chief Justice alluded to, with some qualification in management. Because I felt that although it's an administrative issue, I could have handled it a little bit far more better to avoid the transgression. The transgression has helped me over the years to know how easy it is to find yourself on the wrong side of the rules, and I've used that in my training of candidate attorneys and even at the law school. And so far, I've managed for 21 years to avoid a repeat. But that doesn't excuse the fact that there is that blemish on the record.
Thank you. My last question is on the issue. I looked at your CV. I think it's one of the commendable ones, as CJ has said, in terms of your achievements, looking at the areas of your work, both in terms of commercial law and also forensic investigation areas, which is something that is quite rare, especially for Black practitioners. What are your, I want to ask in terms of transformation of our sector and many of others areas, because we hardly find majority of the people, especially Black professionals or previously disadvantaged individuals in these areas, specializing or being able to get. What can be done to have more into this? Is this the area, one of the areas that you are seeing, you are training in? Perhaps if you can share with us.
Just hang.
Should I continue? Okay.
Issue. Yeah.
Honorable Minister, you are done with the question.
I'm not so sure if you got my question, but it was more around looking at your profile, your qualification in areas that when we look at previously disadvantaged individuals, you hardly find. And I made reference because if you look at both in terms of commercial law, the issues of forensic and investigation, you've done qualifications in that. So I was just listing that, but more so saying whether this is an area, I think, let me just go, mercantile law as well, insolvency, liquidation, and also a qualification, yeah, in forensic and investigation accounting. This, as I said, these are skills that you hardly find. And one of the issues as we deal with issues of transformation, making sure that previously disadvantaged individuals are able to find space in the areas that are not really. What do you think should be done in order to make sure that there's more of you, perhaps I can use it that way, there's more of individuals having access to this specialized areas, but two, is this one of the areas that you are training? And maybe just as I could, because I'm not gonna come back, I was sharing with CJ, I could recognize your name because acting DJ, Judge President is one of the names that I remember quite regularly, as you say, am I quoting your sentiments of him availing himself to act. And most of the time it's actually pro bono or in the work that he does. So I thought I must acknowledge it's very rare to remember names as you sign because it's quite a lot of bundles, but this one I particularly remembered.
Okay, thank you, Minister. I think the challenge has been that you can obviously have the qualifications, the academic qualifications. You still obviously, as the Minister mentioned, you need to get to apply them to get the opportunities. But with the question coming from the Minister, I could say, obviously, matters of budget permitting, you could have the state attorney, for example, being expanded and being, to some extent, being capacitated to offer services, which will require obviously a statutory amendment, to organs of state, which are the entities that generate a substantial amount of commercial work. The reason why I'm saying state attorney, and I'm looking into, at the beginning, obviously the young practitioners coming in, especially from previously disadvantaged background, they need to come in at the level where there's a lesser risk. Maybe state attorney offering employment, that could be there where they get engaged, and while getting experience into commercial law, they also, to a point, get their financial needs met. The other way is to, I think the Solicitor General is there for that purpose, to coordinate procurement from even organs of state, to ensure that that is, the implementation that is there is fully improved, to expose people to the areas of law. The areas of law that are typically commercial law. And the other one is obviously our burden as practitioners to take along candidate attorneys and paralegals in training. I hope that has answered you, Minister. Thank you.
Professor?
Thank you very much, CJ. Good afternoon, Mr. Manamela.
Good afternoon, Prof.
I'm not sure if we will do justice to your CV if we don't talk about the foundation that you and your colleagues have laid in the company's tribunal, where the current members of that tribunal are enjoying the expertise that you laid in that tribunal. I just want to know, in your view,
thank you.
In your view, do you think that the jurisdiction of that tribunal is restricted and that hamstrings it from actually contributing more to the development of company law in South Africa?
Yes, I think I fully agree with that. I think it is restricted. I can start on a comparative level, like the competition tribunal, which is one of the tribunals that I think is lauded, and I think the record is there to say that with its mandate and level of activities, it has been able to deal with matters relating to competition law fully. With the companies tribunal, the challenge is only very restricted to those particular areas of the Companies Act, or the provisions in the Companies Act that are within the jurisdiction of the Companies Tribunal. So if we were to find a way of broadening that scope or jurisdiction, then I think it could, in a way, be able to offer make a contribution that it should really make. Although when I was there, and I think there's an amendment, or there was an amendment that has been mooted to say maybe there is in the area of mediation. That's where the Companies Tribunal could be kept busy, so to speak. But the problem there was that it's voluntary mediation, and we all know what happens, especially where you have parties who come before the tribunal without the equality of arms in the sense of finances. Some can afford to just bypass that and go to court. So I can conclude by saying the Companies Tribunal, the contribution could be far more greater if the mandate is statutorily increased.
There's also discussion about arbitration as well. I just want to take you to a judgment that you wrote, Herr Manas NO versus Ledwaba. I think it is the very first that appears on your bundle. It's in page 27 of your. You did not go to it because I just want to deal with some of the things that are coming from it. In this case, it is a sequestration application, and you deal with sections 8, 9, and 12 of the Insolvency Act. And what I saw, and it's a brilliant judgment in so many levels. But what I want to ask you about is the state of insolvency law in South Africa, where sequestration appears now to have been used as a debt collection mechanism, contrary to what the Insolvency Act intends it to be. In other words, if anyone owes you something, apart from taking them to court, you might as well try to create an act of insolvency so that you can take them to court. What would be your view with regards to understanding this aspect of the advantage to creditors requirement, this aspect of reason to believe? I'm not sure if you have thought about it.
Yes.
Because a lot of emphasis is placed on advantage to creditors. But this aspect of reason to believe, we seldom see it being interpreted and being dealt with by the court. I'm not sure if you have dealt with. I know that you are an insolvency law person, that's why I'm burdening you with this question.
Yes, no, thank you. The reason to believe requirement, obviously in its full extent, is that there's reason to believe that sequestration will be to the advantage of creditors, which is obviously features in compulsory sequestration. And then, obviously, I think you're putting emphasis on it because involuntary surrenders is a direct requirement that there will be advantage to creditors. The primary reason for that is that in compulsory sequestration, the creditor will not be that much aware of the financial circumstances, the nitty-gritties of the assets and liabilities of the debtor. And therefore, it can only convince the court, obviously on a balance of probabilities at the final stage, by way of bringing the facts through which the court could conclude that there will be advantage to creditors, or there's reason to believe that sequestration will be advantage to creditors. So I'm thinking the primary reason for a roundabout test, if I can call it that, was to contrast it with a voluntary surrender where the person who is the debtor, who knows his or her financial affairs, could attest to whether there will be advantage to creditors or not. Whereas with the other one not sitting at arm's length won't be able to do that.
No, that's correct. Thank you very much, CJ.
Commissioner Toro Tlepo.
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
CJ, I think Prof. Marumohai took my questions. I wanted to highlight how modest Mr. Manamela is. He has written a lot on company disputes, and we are still referring to his cases. Thanks.
And I was just thinking that I've never heard Professor Marumohai compliment anyone's judgment before. And here he is throwing words around like brilliant and Commissioner Mangen.
Thank you, CJ. Good afternoon, Mhlalo. Let me add my words to the good work that you have done.
Thank you.
In the space of the insolvency law. This year, the Gauteng division of the High Court ran a pilot project in the insolvency court. Did you have an opportunity to sit in that court?
No, not yet. When I was about to, I think it started is it in the second term, I think, of 2025 in Johannesburg?
Yes.
Yes, that's, I did a first term, full term in Johannesburg, but then I missed it and I thought it should be pushy to say I want to act in that court. I thought the time will come. I may have thought wrong, but I'm hopeful.
Given the fact that it's a pilot project, and I note from your CV that you were once the chairperson and the general secretary of the Association of Black Insolvency Practitioners. Do you see it as a welcome development, or will it continue to create an exclusive court for white practitioners who, in the main, specialize in insolvency law?
Yes, it will. The normal approach is business as usual. People are motivated by outcomes, financial ones mostly. Unless, and again, it's going to have to be through a rule. The one that has got more force will be if we could find a way of making a statutory requirement. But to come directly to the question, the issue of opening up the some other sectors of our industry is possible, but it's just that sometimes we get busy to overlook, and we overlook it. For example, the state organs or state SOCs, state-owned companies, they've got a way of equipping black practitioners or previously disadvantaged individuals. And I think, obviously, if that platform is used, it could create a pool of people who are in some areas of law, including insolvency. But with regard to the court itself, I guess the focus now is still to get the systems on the ground, apply them and see if they're working. It's going to be more into whether the court can run efficiently, for example, alleviate the congested roles in our courts, and also primarily because, and I think everybody will say this with regard to every aspect of law, insolvency law matters are also urgent. And the one that I didn't want to start on is people will talk about expertise to say that you need in those courts people with particular expertise. I think is exposure. Even with a degree, if you don't get an opportunity, it becomes useless because you don't apply. So sometimes you don't even need a degree if you get an opportunity. So yes, it will for a while operate as an exclusively probably white court, or mostly predominantly white. And because probably in those areas that those are the practitioners that are involved. But as soon as it gets going, just like other areas of our law, there will be, I can use the word infiltration from previously disadvantaged individuals. I don't know, I see on your face, I don't know whether I've answered you, but that's my attempt at your question.
No, I'm fine. I'm fine, CJ. I can let it pass. The HHP got a gist of the question. It's going to be important to see who is presiding in that court, but also who is appearing in that court.
Yes, I didn't talk about who's presiding.
Sure.
I think I spoke about who's appearing. Because I'm still at the appearance level, not the presiding level.
Fair enough. Thanks, Chief Justice.
Anyone else? All right. Thank you very much, Mr. Manamela. It was a pleasure interviewing you. You are excused.
Thank you, Chief Justice, for the opportunity. Thank you all to all commissioners.